Hi, I'm Johnny, and my friend Alicia and I are walking you through the helpful information you can find at oklahomadisasterlegalhelp.org. There are an overwhelming number of things to do when your home is impacted by a natural disaster. We've assembled some information for homeowners and the rights and responsibilities they have after disaster. Alicia, where should we start?
Let's start by listing some of the issues homeowners commonly face after disaster. You'll likely need to deal with applying for FEMA assistance, sort out your home's title or deed, make a claim on your homeowner insurance policy, avoid contractor fraud in your repairs, the costs of those repairs, mechanics liens, special tax considerations, and personal property loss. Firstly, if you don't have homeowners insurance, you'll need to apply for FEMA assistance to deal with home repairs. You will be responsible for replacing personal items. But also, even if you have homeowners insurance, you should apply for FEMA assistance. You need to be prepared for any gaps in repairs or recovery that your insurance might not cover. If you need help replacing lost or damaged personal property, you should contact local nonprofit organizations, call 211, visit a multi-agency resource center location, or visit disasterassistant.gov.
As a homeowner whose home has been damaged in a natural disaster, one of your first thoughts might turn to paying your mortgage. Questions such as, do I continue to make my mortgage payments, might come up quickly. Typically, you will need to continue making your mortgage payments on your damaged home, even if you are displaced. You should contact your mortgage servicer as soon as possible to tell them about your house damage. Your mortgage servicer may be able to work something out for you. If your home was destroyed, typical mortgage contracts state that you should use any insurance payouts to rebuild the house. Homeowners also have the option to rebuild with their insurance payouts. These payouts are typically made in your name and your mortgage lender's name. You need your lender's endorsement before you can use the money. Sometimes lenders pressure homeowners to use the money to pay off the mortgage instead of rebuilding, but homeowners have a right to rebuild if they want to.
People ask if a mortgage company or bank can foreclose on a property if payments can't be made. If the homeowner cannot make the payments, then yes, the mortgage company can start foreclosure proceedings. The mortgage company will start the foreclosure process by sending a notice to cure to the borrower. The notice must be in writing, and it must give a detailed statement of the default, including the amount owed and a breakdown of how that amount was arrived at, including the amount of late fees and other costs. The notice means that if the homeowner pays the amount stated in the letter within 30 days of receiving the letter, the homeowner can reinstate their loan and continue with the payment just as if they had never defaulted. If the homeowner cannot pay the full amount to cure the default, the homeowner can call the mortgage company or their attorney to see whether they can make a smaller payment and then pay the rest over a period of time. If the homeowner does not cure the default within 30 days, then the mortgage company can proceed with a foreclosure. The mortgage company will file a petition for foreclosure in the county where the property is located. An answer needs to be filed within 20 days of the date that the original notice was served. The answer should contain all the defenses that the homeowner has to the foreclosure action. Before a judgment is issued, the homeowner can file a demand for delay of sale with the court to delay a sheriff's sale of the house. This remedy is available if the home is the person's primary residence. If the homeowner is temporarily not living in the house due to the damage that was caused by the disaster and intends to return, the homeowner can make a good faith claim that the house is still their primary residence. The demand for delay of sale must be in writing and must request that the sheriff's sale be delayed. It must be filed before a judgment is entered, so it is good practice to file it immediately after receiving the foreclosure papers, along with the answer. The delay of sale will get the homeowner an extra 6 or 12 months, depending on whether the lender is waiving the right to get a deficiency judgment in the event the house sells for less than what it is owed on the loan. If the petition waives a deficiency judgment, the homeowner can get an additional 6 months. If the petition does not waive a deficiency judgment, the homeowner can get a delay of 12 months. To get a delay of 12 months, the homeowner needs to file a demand for delay of sale. The lender can then get a deficiency judgment. A deficiency judgment is only good for 2 years. If the homeowner does not file a demand for delay of sale, the lender cannot get a deficiency judgment. However, there would also be no delay of sale. The homeowner needs to decide which option is best for them.
If you're facing foreclosure proceedings, mortgage help may be available from FEMA. FEMA's disaster housing program helps homeowners who have been forced out of their homes by disasters. Disaster home repair assistance is a part of this program. It provides grants for minor disaster-related repairs. For more information or to apply, contact the FEMA Disaster Helpline at 1-800-621-FEMA. It's also good to know that if you have a mortgage insured by the FHA, Federal Housing Administration, HUD, Housing and Urban Development, or VA, Veterans Affairs, you may have additional protections, like a forbearance on the mortgage payments or a period of suspended payments. The FHA has extended its foreclosure moratorium and offers extended payment plans on FHA mortgages. Call 1-888-297-8685 for further information. Also, the U.S. Small Business Administration offers low-interest loans of up to $200,000 to individuals whose homes were destroyed or damaged by disasters. If you are given a loan, be careful in using your home as security, because if you cannot repay the loan, you could lose your home. You should have a lawyer look over the loan documents as well.
You might be asking, doesn't the mortgage company have to work with the homeowner to help them out? Generally, the mortgage company does not have to work with the homeowner. However, the homeowner should always reach out to the mortgage company to see if they will work with them. The mortgage company may be willing to do so since the mortgage company does not want to have to make the repairs. The homeowner should make sure to get all the terms of any agreement put into writing. It is often difficult to get a written agreement, but even an email with the terms laid out is helpful if there is a disagreement later. But there are options for you to try to save your home. One option is for the homeowner to reinstate their mortgage. At any time prior to the sheriff's sale, the homeowner can ask for a reinstatement quote. This amount will include any money that the homeowner owes to the mortgage company, principal and interest payments, escrow amounts, late fees, attorney fees, court costs, etc. If the homeowner can pay this amount to the mortgage company, the homeowner is said to have reinstated the mortgage. Future mortgage payments will then continue as normal. The homeowner can refinance the mortgage with another lending company. If another mortgage company is willing to enter into a mortgage agreement with the homeowner, the new mortgage company will pay off the existing mortgage to the old mortgage company. The homeowner would then have a new note and mortgage with the second mortgage company. This is difficult to do because the homeowner will usually have poor credit due to the foreclosure action. It may be possible if someone else is willing to act as a cosigner. The homeowner can try to enter a loan modification with the mortgage company. The loan modification will generally result in lower monthly payments for the homeowner. However, the delinquent amount will usually be added to the principal balance, with the mortgage extended to 30 to 40 years to make the payments affordable. FHA and VA loans have specific homeowner assistance programs. Conventional mortgages may receive hardship assistance through programs offered by the mortgage company. Regulations of the Consumer Financial Protection Bureau also provide some protections. So, let's say you get a notice of foreclosure on your damaged home. You need to contact a lawyer immediately. It's a good idea to visit the LASSO website at www.legalaidok.org to see if you qualify for free legal assistance.
Homeowners' issues can be complicated even further when the owner listed on the home has passed away. Title issues are common and can be fixed by contacting an attorney. If you own real property, like a house or land, as a joint tenant with another person and that other person dies, you can transfer the deed into your name only by filing a paper with the county clerk where the home or land is located. You do not need a lawyer to do this. You will have to file some papers with the county clerk. If the property is deeded to you and another person with one of these types of joint tenancy, it can be terminated and transferred into the sole surviving tenant's name using this form. A joint tenancy with right of survivorship with someone who is your spouse. A joint tenancy with right of survivorship with someone who is not a spouse. A joint tenancy with any other person. A life tenancy or the remainderment of a life tenant. If the joint tenant died on or after January 1st, 2010, you will need a certified copy of the death certificate issued by the state of Oklahoma or another comparable agency, if the person did not die in Oklahoma, and a notarized affidavit which must include a statement that you are the surviving tenant, a legal description of the property affected by the death, a statement that the person on the death certificate is the same person as the deceased joint tenant. If the person who will sign the affidavit is a personal representative or is a duly appointed attorney in fact, you'll need to attach one of these to the affidavit. A certified copy of the letters of administration, letters testamentary, letters of guardianship, or power of attorney. If the joint tenant died on or after January 1st, 2010, you may have to file an estate tax return with the state of Oklahoma before you can terminate the tenancy. And if the deceased joint tenant was your spouse, take the copy of the death certificate and your affidavit to the county clerk's office in the county where your property is located and file it. The fee for filing is based on the number of pages you file. However, it shouldn't be over $15. When you have filed the death certificate and your affidavit with the county clerk's office where the property is located, the joint tenancy is considered terminated and you will have title in your name only.
When disasters happen, you may have to deal with pests. Before hiring any company, you should be wary of exterminators who show up uninvited and offer a free inspection. They may use scare tactics to pressure you into authorizing immediate and costly treatments. Deal with a qualified and licensed pest management company. Ask friends and neighbors to recommend pest control companies they have used successfully and how satisfied they were with the service. You can do this online through a community bulletin board or neighborhood listserv. Get bids from several companies. Ask about their training and their approach to controlling pests. Be wary of choosing a company based on price alone. Quality is the most important factor. Before you sign a contract, get details on the extent of the infestation, the proposed work plan, and the number of visits required and anticipated to solve the problem. A reputable company will inspect your property before quoting you a price or beginning any pesticide application. The company also should give you a written inspection report and a plan for preparing for treatment and preventing further infestation. Find out if the pest control company has liability insurance to cover any damage that occurs to your home or furnishings during treatment. If you get a written guarantee, look for what it covers, how long it lasts, what you must do to keep it in force, and what is required for continuing control, prevention, and management. Read the EPA's Citizen Guide to Pest Control and Pesticide Safety, which offers more tips on how to choose a pest control company.
As a homeowner, You also need to know your rights when it comes to repairs or contractor work on your home. If a contractor doesn't complete the job, you'll need to utilize your contract you signed at the beginning of the project. First, the court will look to the contract. If the court finds that the contracted performance was not completed, the court will consider available remedies. One remedy is specific performance where the contractor would be required to complete the job. This is a disfavored remedy. The most likely remedy would be ordering the contractor to pay damages to the homeowner. The court will look to put the homeowner in the same position that they would be in if the work was completed. The contractor will be given value for the work completed, if any, and will be required to return any unearned payments. If the delay in completion caused harm to the homeowner, the contractor may be required to reimburse the homeowner for these damages. If there are penalty clauses in the contract for the failure to complete work timely, the homeowner can ask the court to enforce these provisions. But also, what rights does a homeowner have if the repair work is not completed properly? This is also governed by contract law. In this situation, the homeowner should be put in the position that they would be in if the contract had been properly performed. They would generally be entitled to the difference between what they received and what they should have received. The damages are generally the cost of correcting the defects or completing the omissions.
If the general contractor you hired does not pay the subcontractors working on your project, you need to know that the subcontractors could file a mechanic's lien against the property. A mechanic's lien is a lien placed on a property by a contractor or subcontractor who has performed work on a property but has not been paid. Two common ways this issue arises is if 1. A homeowner hires someone to perform work on their residence and then does not pay for the work that was done. Or 2. A homeowner hires a general contractor to work on his or her home and the general contractor does not pay the subcontractors who perform the work on the home. A homeowner will receive notice if a mechanic's lien is placed on their property. The lien registry administrator will either mail a copy to the homeowner or the homeowner will be personally served with notice. So, how can you remove a mechanic's lien? The first option is to satisfy the lien by paying what is owed to the person who did the work. The homeowner should keep a copy of any payment made. The contractor should then file a written satisfaction of the lien with the lien registry administrator. They can then make a written demand that the contractor acknowledge satisfaction of the lien to the lien registry administrator. If it has been more than 30 days since the written demand was sent and the contractor has not filed a satisfaction, the homeowner can file a copy of the payment with the administrator. If the homeowner does not agree with the lien, the homeowner can challenge it in court. If the lien is for less than $10,000, they can bring a challenge of their own in small claims court. If the homeowner challenges the lien, they can also assert a claim for money damages if they believe the contractor owes them money. The contractor that put the lien on the house can also file in court to enforce the lien. If the homeowner does not think that the contractor did a good job or completed the work, they can object to the amount of the money that the contractor claims is owed. The court will hear the evidence and decide. The court could decide that the home will be sold to pay off the amount owed.
What if the homeowner lost livestock due to the disaster? What programs are available to help them? You might be able to make use of the following programs: Livestock Forage Program, Livestock Indemnity Program, Emergency Livestock Assistance Program, or the Non-Insured Crop Assistance Program. It's also good to know that the Oklahoma Cattlemen's Foundation Natural Disaster Relief Fund has an application for 2019 storms, so check with them to find out accurate information regarding disaster recovery. If you have damage to your crops, livestock, farm equipment, or buildings, you may be eligible for the USDA's Disaster Assistance Program. To determine eligibility, contact your local Farm Service Agency office. And more information can be found on www.fsa.usda.gov in the Agricultural Disaster Resources Guide for Oklahoma.